Welcome everyone. Thanks for joining us today. For anyone who doesn't know me, I'm Amanda Tolson, one of the three directors here at Clifford Gouldson. I head up the commercial and property team, and I'm joined today by one of the members of that team, Brailak, who joined us a little over 12 months ago from Brisbane, for anyone who hasn't met Carly. Today we're talking about the COVID rent regulations, and it does feel like a bit of a part two from a webinar we held on the 14th of April for anyone that also joined us for that one. And it was such an uncertain time then. I presented that webinar here from the CGLaw office, but I was one of only 4 out of our 30 staff who were still working from here. Carly was presenting from home that day, where she and the rest of our staff worked for about 7 weeks. Given the dire outlook we had then, I think we're actually in quite a good place in Queensland, at least, maybe compared to how we thought we might have been, reflecting back what we were thinking in April. Economically, of course, it's a bit of a different story. And that's really the reason why, even though we've been out of restrictions since July in Queensland, we're still talking about rent relief for commercial tenants. So what we wanted to cover today, so in that first presentation in April, we talked about the initial version of these regulations, or what it was shaping up to be there from the mandatory code of conduct that the Commonwealth Government had presented at that time. First, today we'll look at the amended regulation, which was extended recently, and how it differs from the initial version, which was in place prior to 30 September. Carly is then going to address some matters to consider when documenting the rent reductions agreements which have been reached, and some flow-on considerations from those. And then we'll also talk about our experience with mediations under the regulation. We've participated in 2 within the last month, one for a landlord client, one for a tenant client. And I forget where someone was talking to the Small Business Commissioner, but somebody advised there's only been 7 in total in Toowoomba. So it seems like most local landlords and tenants have been able to reach agreement without needing to go to that next step of requesting mediation, which is good, but we'll seek to dispel some of the mystery that surrounds that mediation process. And then lastly, we wanted to discuss some of our experience of how the regulations worked in reality, and how we've seen landlords and tenants conducting themselves when negotiating these rent reductions under the regulation. I know listening in today, we've got some really experienced agents and other people who have also been very heavily involved in those sorts of discussions. So certainly feel free to put any commentary you'd like to share in the chat box, and we'll share those. And if you've got any questions throughout today, please send them through that chat mechanism, and if we have time, we'll get to them at the end. We do have a lot to cover in the 30 minutes, so if we don't get to them today, if you could please include your email address, we'll endeavour to come back to you after the webinar. So first, just in terms of background, how did we get here? I just wanted to reflect upon the timeframes and the process to get us where we find ourselves now, for anyone that didn't take part in that first webinar. And I guess because we all do forget so quickly, that it wasn't so long ago we were hanging on every word from Scott Morrison's press conferences and the outcome of those national cabinet meetings, to try and understand what measures would be put in place to assist parties to commercial and retail leasing, really navigate the fallout of the pandemic. So after what seemed like an eternity, the National Mandatory Code of Conduct was announced. So you can see there, some of the principles were first announced on the 3rd of April. The actual terms were then settled with National Cabinet and announced on the 7th of April, and the document was actually released at that point in time. But as you can see from my creative phone clip art pictures on my PowerPoint slide here, you can see the points in the process where our phones were really ringing off the hook, because people just wanted to know what was going on, what they could do, what they couldn't do. And look, as lawyers, we genuinely don't like having the answers, but at that point in time, we just didn't. So it's interesting to suddenly be seeing these limitations on the Commonwealth Government. So, Scott Morrison's up there talking about what they intend to do, I guess, as a national group to manage what was happening at that time and support businesses, but he wasn't able to legislate on it. So they had these principles set out in a mandatory code of conduct, but they could only then pass it on to the state governments to actually introduce their own legislation and in their own time. So the Queensland government, I believe, was one of the last. So after the principles were worked out and announced on the 7th of April, it wasn't until the 29th of May that those regulations were actually released. So that was the catchy title, Retail Shop Leases and Other Commercial Leases, open brackets, COVID-19 Emergency Response Regulation 2020. So they kept us waiting for a fair while, and it was pretty difficult. People were trying to negotiate things before that came out based on the mandatory code of conduct, because it actually applied to affected leases. The original response period was 29 March to 30 September. So you literally had 2 months there from the end of March to the end of May where these regulations then retrospectively applied. So as that 6 months was then drawing to a close, in terms of 30 September, there were rumours abounding as to whether or not the operation of the regulations was going to be extended further beyond that 30 September date, despite the lockdown having lifted a couple of months earlier. Other states extended their regulations, but there was no word from the Queensland government until very late in that period. So I think that previous slide showed, I think it was 16 September, before the Queensland government actually announced they would extend it. And it wasn't until the 29th of September, I believe, that they actually released the amended regulation. So we were in the midst of a particularly heated negotiation on behalf of a tenant client at that time with an overseas-based landlord, and we really needed to know how these extended regulations were going to work. So one of the lawyers in our team actually ended up on the phone to the relevant department, and surprisingly the same day actually received a return call from the head of that department, being the Small Business Commissioner, indicating that she'd been waiting on this the amended regulations for some months and seemed to be as frustrated as we were. But eventually, one day before the previous regulations expired, the amended regulation was published, and the terms on which that rent relief would be afforded to tenants in what became known as the extension period there from 1 October to 31 December was eventually revealed. And that period was quite distressing for tenants in particular, especially where they had negotiated deferred rent, which was to commence being repaid from 1 October. So the differences between that original regulation and the amended regulation, so it wasn't just extending that time frame from the end of September to the end of December. There was actually some other changes to the content. So first and foremost, the relief offered was extended to 31 December, but in order to qualify for that relief, the tenant had to demonstrate eligibility for the JobKeeper scheme for the period starting 28 September under JobKeeper and ending 4 January, which under the extended JobKeeper scheme requires a retest based on the September quarterly figures. So that's in addition to the existing criteria as well, which was in the original regulation of being an SME entity and having the binding lease agreement. So under the original regulation, rent reviews couldn't be applied until after the expiry of the response period on 30 September. The amended regulations then came in, and any rent reviews that fall during either the initial response period or that extension period cannot be implemented until after 31 December. So it's kicking that rent review can further down the road again. So the prohibitions on landlords enforcing leases against the tenant have also been extended as expected, with no changes. So again, that's around terminating leases, enforcing security as well. So the regulation provides where a rent reduction is negotiated in respect of the original response period. So that first version, the landlord had to offer a minimum 50% of that rent reduction as a waiver, as a complete waiver of that rent payable, with the balance being able to be deferred until after the response period. With the extended regulations, the 50% waiver rule doesn't apply to rent reductions during the extension period. So after 1 October, any rent reduction negotiated could actually be fully deferred and no waiver component. And the payment of the deferred rent can then commence from 1 January next year. We should also stress at this point it's still open to the parties to reach an agreement that's not consistent with the provisions of the regulation, provided it's acceptable to both of them. The one exception to that is the rent reviews. Even if a tenant agrees to apply a rent review, they can't actually agree to that, and it has to be kicked out till the 1st of January. So it's always been the case, a tenant, even if you negotiated, for example, under the first version of the regulation, a tenant was always able to go back to a landlord to renegotiate a rent reduction after an agreement was reached, where the grounds on which that agreement was reached have changed in a material way. So let's say, the tenant negotiated right through to 30 September on the expectation their turnover would be down 30%. And let's say towards the end of that period, it was actually down 50%. The tenant was always able to go back to the landlord and seek to renegotiate the rent reduction that they'd negotiated with the landlord. The amended regulation actually provides that where the tenant has a second bite of the cherry, so to speak, in relation to a renegotiation for the first response period, it's not required to comply with that 50% waiver. So if a tenant wants to go back and redo any part of that first response period, the 50% waiver is out of the equation and all of it can be deferred. So as you can see there was a couple of important changes just to keep us all on our toes. And I'll now hand over to Carly just to discuss our experience in documenting agreements reached under the regulation.
Thanks, Amanda. So looking at documenting our rent reductions, there's a few things to be considered. We've actually seen quite a few clients going it on their own and documenting their own arrangements relatively informally. In some cases, just landlords issuing discounted rent invoices to tenants or revised invoices to tenants, or giving an exchange of emails and just relying on that. Where the reduction that you're documenting is fairly simple and is just limited to a discounted rent for a short time, that might be okay. But where you have arrangements such as agreements to defer rent for an extended term, particularly after the expiry of the lease, or where you've agreed to extend the term of the lease, it's prudent for the parties to enter into formal documentation to record the arrangements that have been reached between them. Deferred rent under the regulation can be repaid during the period that's 2 to 3 years after the expiry of the extension period. So for landlords, a key reason to formally document your arrangement is so that you have something concrete to action or sue on if you need to, in the event that the tenant doesn't comply with its obligation to repay that deferred rent. If you don't have evidence of the agreement that's been reached, and if it's just a he said, she said arrangement, and you can't demonstrate equivocally what the terms were or whether they were agreed by the tenant, you don't have a lot of evidence, and it's that much harder to prove default on the part of the tenant when it comes to those deferred rent terms. Another reason to formally document your agreement is if an extension of the term has been negotiated as part of the arrangement. Under the regulation, where rent is waived or deferred, the landlord must offer the tenant an extension of the term of the lease on the same conditions as the lease, except that the rent payable during the extension must be adjusted for that waiver or deferral. The tenant isn't obliged to take up that offer, and we've actually seen very few extensions of terms as a result of these deferrals and waivers, except where that deferred period might go over the end of the lease otherwise. So the period of the extension that you need to offer as a landlord is equivalent to the period for which rent is waived or deferred. So potentially we're looking at up to 9 months extensions that you're giving to your tenants or offering to your tenants. There is an exception to that rule, and that's where, well, there's actually two. One is where you have a binding agreement for example, if you've already leased the property to someone else after the expiry of the current lease. And the other one is where the landlord can demonstrate that it requires the premises for its own commercial purposes. Now, formally documenting an extension of the term becomes even more important where the lease is registered. Unless a Form 13 amendment is registered on title to the property, the title will continue to show the old expiry date. And this is important if you have options, particularly after the end of the term, because the Titles Office has rules about when you can lodge documents to give effect to extensions. And if you lodge them too far after the end of the initial term, or they're not in accordance with the term, then it may prevent those documents from being registered on title. Another consideration when you're documenting a rent reduction or agreeing to a rent reduction is that if the property is mortgaged, there will almost certainly be a requirement in the mortgage that the landlord or property owner obtains their mortgagee's consent to any variations of the lease. A reduction in rent, an extension of term, changes to the other conditions of the lease would all fall into that category. So landlords should always bear this in mind when making agreements with their tenants, and any agreement that they reach should really be subject to obtaining their mortgagee's consent. We haven't actually seen any mortgagees not giving their consent to these rent reduction and extensions of terms, but as a procedural step, the landlord should always make sure that they ask the question to make sure that they're not in default under the mortgage and hand the mortgagee an opportunity to exercise its rights under the mortgage. Particularly where an extension of the term has been agreed, landlords should also check any security that they hold for the performance of the tenant's obligations under the lease. Most bank guarantees these days will contain an expiry date, and they're usually around the date of expiry of the lease or within that 6-month period after. There are still some that don't have an expiry date, but in my experience, they're becoming less frequently used. So if you agree to extend the term of your lease, it might be the case that your bank guarantee expires before the tenant's obliged to vacate the premises or before they've fully complied with their obligations under the lease to make good. So landlords would be quite within their rights to make it a condition of the extension of lease that tenants provide a replacement or further bank guarantee to cover that extended period. The other thing that landlords should do is make sure that they actually follow up on that request. It can take some weeks to get a new bank guarantee. You might need to arrange an exchange, but it's definitely something that landlords should follow through. And lastly, can or should landlords and tenants document their own arrangements? We understand that at a time when tenants are approaching landlords to ask for rent reductions, it's because there's not as much money going around. It's because their businesses aren't doing well. It's because landlords aren't getting as much rent as what they would otherwise do. So we understand that people would want to save on legal costs at that point in time. So where the arrangement isn't complex, it's just a simple rent reduction for a short period of time, it might be possible to effectively document that yourself. But if you are doing something a bit complex, if you're doing an arrangement that has deferred rent, an extended term, changes to other conditions in your lease, we would definitely recommend that you seek some professional assistance in documenting that. And certainly from a landlord's perspective, it may mean that you save more money in the long run from having an enforceable agreement where you might not otherwise have had one. Okay, so moving on now to our mediations. The regulation, as you would all know, establishes the right for either the landlord or the tenant to apply to the Small Business Commissioner for a mediation of their lease dispute that has arisen under the regulation. The mediation is not intended to determine the dispute in a way that a court would, or decide who wins, or to decide who has a stronger case. It's merely a forum for the parties to discuss their dispute on a confidential and without prejudice basis, with a view to reaching an agreement so the parties don't need to take the matter further to QCAT or beyond. And to say that it's without prejudice simply means that whatever is said in the mediation can't then be used against a party in court if that's where the matter ends up. And this is to give the parties the freedom to speak frankly in the mediation and hopefully maximise the chances of an agreement being reached. The mediation process under the regulation isn't a mandatory process. The parties can go off to arbitration or resolve the dispute in another way if they wish. But if the parties do want to apply for a mediation, it is a prerequisite that they must have attempted to first resolve the dispute themselves. And each party must cooperate and act in good faith when they're trying to do that. Either the landlord or the tenant can give a notice to the Small Business Commissioner to say that there's a dispute. The Commissioner then decides whether to accept or dismiss that dispute notice. And the Commissioner may only dismiss that notice if it doesn't relate to an eligible lease dispute under the regulation, if it's frivolous or vexatious, or if it's not being given in good faith. Once accepted, the Small Business Commissioner will then appoint a mediator and advise the parties who that person is and of the date and time for the mediation. So the mediation that we've been involved with have been conducted via a teleconference, although it can be by video conference or in person or any other technology that allows the parties to communicate at the same time. If a party wants to be represented by a lawyer, that request has to be approved by the mediator. In our experience, we've not had any difficulty obtaining that approval, particularly in circumstances where the matters that we've been involved with have involved a lot of correspondence going backwards and forwards between the parties before we've gotten to the mediation, and it's often raised some very complex issues. The regulation isn't as prescriptive or as clear, and it doesn't take into account every situation that we'd like it to. So there is certainly a lot of room for different interpretations of what's required, particularly in relation to the type of evidence and information that each party is required to give the other party. The parties to the mediation, once it's scheduled, must attend unless they have a reasonable excuse not to. Once you do get to the mediation, you've only got 2 hours that is effectively paid for by the Queensland Government. We've had one mediator who was quite willing to go beyond the 2 hours if that meant reaching a resolution. And we've had our other mediator say that no, 2 hours is up, cutting it off, you're on your own from here. And a certain portion of that 2 hours is initially taken up by the mediator making some opening statements to the parties. They confirm that they don't have any association with either party, they're not in conflict. They confirm the nature of their role in assisting the parties to reach a resolution, and reiterate that their role is not to find in favour of a particular party. They also don't provide advice about the law, and just by coincidence, we've actually had family law practitioners appointed as our mediators. So leasing disputes certainly wasn't their experience. Each party will have an opportunity to state their position, and then typically the mediator will try and find where the parties can agree and where they're apart, and seek to bridge that gap of where they're apart. During the mediation, you can go offline with your legal representative to discuss offers that might have been made or to formulate counter offers, and then you come back together and hopefully have an agreement. But if you haven't reached an agreement at the end of the mediation, all is not lost. You can continue to negotiate afterwards. And in our experience, the ones that we've been involved in haven't settled in mediation, but have done so in the days and weeks that followed. At the end of the day, if a settlement agreement really can't be reached, then either party can apply to QCAT, and away you go to determine the dispute that way. So I'll hand back to Amanda now to talk about our experience of the regulation.
Thanks, Carly. This was just sort of a part where I wanted to discuss some anecdotal observations that we had. This year's certainly been one of those times where I've had lots and lots of general conversations with people about what they're seeing, and swapping stories about what's happening in our respective industries and geographical areas and what we're seeing on the ground. So look, if anyone's got anything that they'd like to share in this section, please feel free to send it through. Now, this first point, I really wanted to use that phraseology, the good, the bad, and the ugly. But overall, I'd actually say that our exposure to most lease negotiations falls within one of the two extreme categories, the very, very good or the very, very bad, where both landlord, most have been the very good, I think. Both the landlord and tenant have negotiated with all the good faith that our fearless leader, Scott Morrison, requested that they have, to reach an agreement that both parties feel is fair. And then the other much smaller categories of negotiations we've seen is what I would describe as very, very bad. We've seen some tenants seeking to unfairly utilise the legislation to obtain a rent reduction they may not be entitled to, or landlords who've been asserting that the pandemic's not their fault, that the legislation overreaches into private lease arrangements, and that their tenant should have to ride out the rough time under their own steam. Thankfully, we've had very few fall into that latter category, and the majority have negotiated and documented their rent reductions largely without our assistance, as we've said. So what else has made this year unusual? I know that's a long list, but I guess that next point, we found ourselves advising from press conferences. Now, I know there are also a couple of accountants who've logged in. They're likely to tell me to quit my whinging, because every year at tax time, I know that accountants are negotiating on the changes to tax laws from the budget announcements. But it's really been a unique time in my career, and certainly most property lawyers, to see government intervention in leasing to this extent. The pillars of leasing, like the obligation to pay rent while you still have use of your premises, has largely been unchanged since Federation. The states have fiddled around the edges occasionally, mostly with retail leasing issues, but really, as a lawyer, it's been one of the most unchanging areas of law in which to advise, and then COVID's come and really turned that on its head. So the frustrating part was having the phone ringing, like I mentioned earlier, and no ability to give real legal guidance, given the lag between announcements, because the government was keen to show that they were doing things, that they understood the pressure was on business, those announcements, and then the legislation coming much later in time. So that next point, behaviour and confidence being very localised, I think we've really seen that, which seems quite obvious, I guess, when we compare our experiences compared to, say, Melbourne. But it's still surprising, I guess, when we were speaking with colleagues and clients, who are Brisbane-based back in July, where I could tell them that I'd look out my window here at Ruthven Street, and really things got back to normal very quickly, while there were still, they were telling me there were still tumbleweeds blowing down Queen Street. So given the expectation is that COVID's going to continue to pop up in different places in different ways, perhaps until we find a vaccine, I think that's really going to continue, this, localisation of experience. And some surprising good news stories. Look, there hasn't been a lot, but I wanted to try and end on a positive note. But I've been surprised that they have popped up where you wouldn't expect. We've heard some restaurants who have capacity to host larger groups have actually seen an improvement on their numbers from last year. We had those caps on gatherings in homes, and the ongoing uncertainty around whether they might crop up in the future when people are planning for milestones, sort of birthdays and other events, has seen an increase in bookings in that space. We've also got our clients in trades telling us they're seeing a really big increase in work due to those, overseas travel dollars perhaps being spent in home renovations instead. So, a couple of good news stories there. Just flicking to the conclusion, I don't think we've had any questions come through. So thanks everyone for your attendance today, and to Carly for her insights. And while we've greatly enjoyed these webinars, I sincerely hope we don't have more phases of this legislation to talk about, so we don't have a third webinar on this COVID rent topic. So fingers crossed. We wish you all the best in these unique times, and look, please don't hesitate to reach out if you have any questions. We're always here to help and point you in the right direction if we can. So have a great afternoon, everybody. Thank you again.
Thank you.